what would be the steps that you would recommend as an inventor? What does I need to do to decide if it's suited to file a patent, if I can file a patent, if I meet the criteria, and what will be the role of a patent attorney in that process?
Basically, you could do a lot of work already yourself, because the first thing that we have to distinguish is whether your invention is suitable for patent protection or not. We request often an inventor to give us an as detailed as possible description of his invention, and basically also that he will at least think about the future. What can he amend, or what can he surplus add to the invention for the future? And we will ask the inventor to write it down. This can be in French or in Dutch or in English or in German, whatever. Write it down and be as complete as possible. Now, if the invention is suitable for patent protection, we first are going to request the inventor to do a search. We can do that ourselves through databases which are not for free, or we can do that together with the inventor on patent databases which are for free. And there is at least 3 or 4 databases where the inventor himself can already search and see what already exists in what we call the prior art documents, or in the state of the art. Because one of the main requirements of a patent is novelty. And novelty requires that you should add something to what already exists. And what already exists is normally the document that comes most close to your invention. So together with the inventor, we are going to try to identify the document which is the most closest document. This can be done through databases which are for free, such as the database of the European Patent Office, ESPASnet, or databases of WIPO, World Intellectual Property Organization, or through even the Google Patents in Plurality database, which only concerns US documents, but it's easy to find because it's a full search, full text search that you can apply to the Google patents. So this is the first step. First of all, identify whether what the inventor has is suitable for patent protection, and if it is, do a search, a thorough search, because that will learn the inventor more, because normally he will only know what is commercially available, not what's available in prior art in the patent literature. So this is the first step. And the inventor can do it on his own, or together we can do the search, or there is also some instance, for example, the Ministry of Economic Affairs in Brussels, they can do the search for you, and it doesn't cost so much. Because you always have to see that using a patent attorney is not a cheap issue. A patent attorney will charge you probably 200 to 250 euro an hour. So if you're a small company, that's a lot of money. And you should really know in advance whether and where you can use him for your purpose. So the first exercise is you come with your inventor to a patent attorney. The patent attorney will see whether your invention is suitable for patent protection. And if it is, we are going to try to find the most closest documents available on the internet.